This ain't prophecy. This ain't hate. Just history watching itself repeat. When words get reckless, the courts get busy. And the truth always shows up right on time.
Hey, everyone. Skynet. Thank you so much for your gifted membership. Fluffy pink socks. Welcome to our member. But you are a Mutton's cousin now. Skynet, I added a wrench. Hey, balls. I saw Renell in here too, didn't I? How are you doing? Let me see who all's in here. Donna. Did you get your hair done in time? Are you going to be mad if you have to join late? Hey, Sunshine and Rain. Hey, Skynet. So if you, Skynet, you'll see that I put a wrench by you. I don't have any expectations from moderators other than if I'm not paying attention and someone comes in and starts bashing another creator or starts doxing anybody. I don't want anybody to be banned or whatever. You just silence them. Like you have an option just to click on that statement and just mute them for a while. Okay, because sometimes I don't pay attention. So sometimes I don't have enough moderators in here, and I know that you're in here a lot, Skynet. So again, I don't have any expectations from moderators other than if I'm not paying attention and there's a comment that is talking about you know what I'm saying, derogatory. If they say derogatory things about me, that's fine. I'll catch it. But if it's about another creator, if it's about especially like Miranda or James, or if they start putting personal information about somebody in here that's questionable and I don't pay attention, just mute them. Yeah, we have a very good chat. I don't see anything happening, but anyways, hey, Camping Mama. Hey, Donna, you are here. Susie Flies, Christine, Goose, you're not green. What is going on? Skynet is trying her damnedest to get you to be green. We'll figure it out. Who else am I missing? If I'm missing you, it's because I haven't scrolled up in chat yet. Somebody sent me some jewels, so thank you for that. Short order. Good to see you as always. Again, hey, Sarah. Again, if I didn't say hi to you, it's not because I'm not acknowledging you. Susie, thank you so much for being a member for 8 months. She says, I love Southern Mutton. You are the best. Why, thank you. Hold on, what is going on? Uh-oh. Don't tell me I'm having these already. Hold on, y'all. What is going on? There. I don't know what was going on. I can't pin your comment, but I appreciate you. I don't know what's going on, Susie, but thank you. I was going to pin your comment. Good morning, Kitten on the Keys. Y'all, we have a good one today. We have a good one today. Let me turn my camera on real quick. Y'all, I hate this. I hate, let me see. I hate whenever I put a virtual background. Like, it makes it so fuzzy, so I never use it. Oh, thank you, Susie. I appreciate that. Yeah, I'm only a member on a few channels myself. Howdy. I don't know why I can't scroll up and see chat. YouTube has been misbehaving, tripping. Hey, King Yukon. You read that. So raise your hand in here if you've read any of the filings. I hate how this looks. Hang on. Let me try something. I'm going to take the background off. You can see where I'm sitting. I don't give a shit. I'm sitting in our spare bedroom. It's not that comfortable. But anyways, here I am. We have some good ones today, y'all. I don't know why. Okay, I've got some. Y'all, I'm going to exit out and come right back in. I got something going on with StreamYard. Thank you so much, Hot Tea Drinker, for the jewels. Y'all, I got to exit real quick. I'll be back in 2 seconds. Okay, let's see if this is why. What the hell is going on? Hang on. All right. Can y'all hear me now? Can you hear me now? Can you hear me now? I have no idea what's going on. Okay, y'all can hear me. I have no idea what just happened. It put me in here. It put me in here. Okay, good. It put me in here like I'm not going to turn my camera back on because I don't know what the hell. I know, and you know what? I'm missing everybody. I had all my tabs open to share, so now I got to go back and redo all of this. But that's fine. We're going to get through this, y'all. We're going to get through this. I promise. It's the curse of KJ. I know, because we've got something good to go over. We've got some good stuff to go over, y'all. Some good stuff. You know, I'm sure you saw this. Okay, so here's the one thing that's written in here. I'm going to wait for this stuff to kind of upload to pull itself back up, and then I'm going to sign. Okay, let me see here so I can see everybody's comments. But okay, so if you're on top chat, change it to live chat or all chat, so you can see all the comments. Tennessee Nana, good to see you. Ginger Lee, good to see you. If I didn't say hi, Trippin, Susie. Okay, hopefully everything's going to be sorted out now. Here's one. This is pretty much how he opened this. This lawsuit is about a social media agitator masquerading as an investigative journalist, in quotes, who has ruined the lives of plaintiffs by manufacturing false accusations against them and posting them on the internet for clicks, revenue, and attention. Tell me this guy, I mean, they got this shit quick, y'all. They got to this quick. There's a lot of things that we're going to be going over. But he says, because defendants disseminated all these allegations with no factual evidentiary basis, they have lost protection under the First Amendment. A social media agitator. Yes, Christine. Okay, Balls, you're still here? That was the best introduction. I'm assuming you probably posted this, Balls. I haven't been on Instagram or Twitter. I don't know who else posted it. So raise your hand if you've read it. Y'all, this is good. And so his response attacks Katie Joy, her motion on so many individual levels, y'all. So many. And we will kind of go through that. But basically, he said there's a lot of things. Okay, remember all the things that Katie Joy was arguing, right? Oh, you did, Balls? Go check out. Do you post on Twitter and Instagram? X? You saw it from Balls, Christine? Did you put up the entire you usually put up the entire filing, do you? You didn't understand some of the jargon, but still quite impressed. We're going to break it down. Virtual raise his hand. So Skynet did, Hot Tea Drinker did, Susie Flies, Balls was on it. Team lawyer, yep. Her dream team lawyer, y'all, the time. My attorney is so good, so good. She's way in over her head, Goose. Balls, I was laughing so hard too. Did anybody else read this and just laugh? Y'all, I couldn't stop laughing. So, I mean, this is how it starts. This is how it starts. Now I got to pull up this other. Let me see if I can find this again, because if not, I have it all highlighted and stuff. And then if not, then I'll just pull it up from their website. Let me see. Pull that up. It was great. Couldn't stop laughing either. Skynet says, you did, Laura? A lovely soul posted it on Reddit. See, I'm never in the Reddit, so I'm glad. Glad someone posted it there too. Agitating YouTuber. I know, right, Laura? Yeah, it was pretty funny. Todd Chrisley would love this. You know, it's funny because I thought the same thing. I was like, oh, man. Look, y'all, he made it. So he just made it so Like, he just insulted them left and right, like, so easily. Like, he just broke it down so easily. But we're going to get into this. Let me see if I can find this again, because I want to share the one that I highlighted, just because, you know, so it'll take us forever to get through all of this. Okay, I found it. Let me pull it up. I can pull it up on their website too, but all right. Bear with me, y'all. I'm sorry. Shelly said, "You almost peed my pants laughing so hard when I read it." I know, and it's very well written, obviously. Look, here's my thought, and then we'll kind of get into the details of it all, right? Amber Stabbig did such a good job bringing getting them to where they're at. And then they hate, handing the baton over to this guy is like, for me, it's the beginning of the end for Katie Joy. She just needs to just stop paying her attorneys and just show up to trial, because she's not going to win this. This is my opinion. It's like, yeah, it didn't seem like they even had to try. And they knocked, just the facts. I mean, they knocked everything down. Like, so her argument, basically he's saying, that the Minnesota UPEPA, which is the Minnesota's anti-SLAPP law, it doesn't apply because the causes of action existed before that statute took effect. So they argued that. We're going to see that. What else was there? That many of the statements that survived summary judgment, so she shouldn't get another opportunity to dismiss them. And not only did it survive initial summary judgment, she filed a motion to reconsider, which was granted. So then there was a whole reconsideration, and it survived that, right? And this guy is saying, I'm just going to call him, should we call him Mr. John, or should we call him Mr. Ella? The golden goose is cooked. I'm going to call him Mr. Ella. I feel like he does. I mean, if you look at his resume, this guy deserves, like, we should probably call him Sir Ella, right? We'll call him Mr. Ella. Will Katie Joy's hubby stay after Katie loses it all? That'll be a true test in marriage, I think. This is the longest Katie Joy has been quiet. Something, and that was still when Amber was the attorney. I'm telling you, something happened at that hearing February 9th. And something happened at that hearing, and she's been quiet. She did a video that night, and basically saying, if I go to prison, it's because they framed me. They're framing me. They're saying that I caused the whole FBI raid. They're framing me. Yeah, her smug arrogance, and that's with everything, isn't it, Goose? With every situation she's been in. Don't cook the goose before they get a membership. But he's saying, look, she doesn't get a third shot at this. Like, why are we going to give her a third shot? All these statements, all relate back. Okay, they're all relate back to the original claims. Okay, so, and those original claims, these new claims are really no different. And we'll go through what he says. But one of the most interesting things to me is, that they say that they argue that 7M, they say they're private figures, okay? And because Katie Joy is calling them public figures. And we're going to talk a little bit about that, because his argument is very solid, obviously, right? This guy obviously knows his shit. I don't think Amber ever argued it, because there was really no need to really argue it, because look, as we know, in order for defamation to survive, with a public figure, you have to prove malice. And that's what they've gone for in the past. And that is what this judge has said in the past, right? In these past rulings. And so I don't understand. I think, y'all, I just think Katie is just so screwed. But she's saying that they're public figures, right? And he's saying, no, they're actually private figures. Because in Minnesota law, to be a public figure, you have to put yourself into public controversy or into a pre-existing public controversy. And his argument is that they were not part of a public controversy until Katie Joy created it. And we're going to look at that and how he argues that. He says that Katie Joy's statements and her statements alone generated this controversy and pulled the plaintiffs into the public eye, therefore making them public figures, but that they're really private figures. And according to Minnesota law, I think obviously he has a very strong argument. He wouldn't argue it if it wasn't. Yeah, it was interesting to see how they argued they were not public figures. And I think we all just assumed, okay, well, they're actually agreeing to the fact and fighting to show that it was actual malice. So I just assumed that they were, like deeming them public figures. And I was just like, okay, we'll just go with it. Amber Stavik has briefly brought it up before and said, just because Katie Joy is calling them public figures, we've never gone that route. And, Katie Joy is saying, well, all these statements I made are matters of public concern, right? And 7M is like, no. The 200 plus statements were focused on the plaintiffs themselves, okay? Rather than being part of a larger public discussion, larger, public concern, whatever. And then it was interesting because they brought up a case, and we'll look over that, comparing it to the the Me Too movement, right? Hashtag Me Too. And it's very interesting. So we'll go through that. But, basically, obviously they're saying that their complaint satisfies Minnesota's pleading requirements. They've done everything. And y'all, they point out like procedural defects in Katie Joy's filing, and it's funny as hell to me. Okay, there's a few that they pointed out. They're basically saying, okay, in my opinion, they're literally saying you're a dumbass. You're a dumbass. At every turn, you're a dumbass. That's how I read it. That's my opinion. He's just doing his job, so he's probably not in his mind thinking she's a dumbass. He might be. Can't speak for the man. You feel badly for Jennifer? Imagine having KJ as a client. Yeah. I really am starting to think that it was the February 9th situation, because we have to remember that 7M, just days before that hearing, submitted their motion to amend the complaint. That was just days before. And when they did that, they brought in all of the statements that Katie Joy made after the fact. The really, really, really damning ones, right? Jennifer Moore might not have been aware of that. I don't know how or why, but she might not have been. Hey, Renelle. They're not wrong. She's a dumbass. Yeah, that's just my opinion. I don't know, Susie Flies. Yeah, we've known for years she's a dumbass. But, I do think, we've said from the very, very beginning, so many in my chat have said that they believe that that Katie Joy writes a lot of her stuff. And that, maybe Jennifer Moore just files it, whatever it may be. I'm sure I don't know. I really don't know. But I am starting to think that maybe she really didn't know. And maybe she threatened to stop representing her if she kept talking once she realized what she said. I don't know. But nonetheless, they make a lot of arguments. You know how Katie Joy made the 4, here, let me put this up real quick before we put that up. I think it's important that we look at this. I know you probably cannot read this, but let me see if I can read it for y'all. Katie Joy in her big argument, remember she said, I'm going to categorize this in 4 buckets, right? And she's basically saying, a royal dumbass. Yeah, you know what, Goose? I mean, I don't understand. I don't understand the whole representation. I'm sure Jennifer Moore, she's in over her head. She was with Amber. I think that they were closer to being able to be a decent. I don't even think it would have been a decent match. But this guy, they have no shot, y'all. That's my opinion. Thank you, Zuna, so much for the jewels. I appreciate you. A marshmallow high. I can't see it. Sometimes it shows it, sometimes it doesn't. I think it's where I'm at in chat. So remember, Katie Joy basically broke this down into 4 buckets, right? And she said that the bucket number 4 I'm reading from here. Bucket number 4, the largest, consists of 113 statements published after UPEPA, again, their anti-SLAPP law, May 25th, 2024, effective date. These were never subject to summary judgment analysis and cannot survive dismissal under Minnesota statute 554.13 on this closed record. And bucket number 2 consists of 15 statements published between April 8th, 2022 and January 1st, 2024, which she's saying are time barred, right? Because they are, they fall into the, what's the word I'm looking for, y'all? Well, the time barred, right? And you know what I'm looking for. So she's saying that before the anti-SLAPP started, between that time and after she was served, that the statute of limitations had passed. So those statements don't apply. Okay, that was another bucket. Another bucket 3 consists of 7 statements published between February 4th, 2024 and May 23rd, 2024 that are timely, but predate the anti-SLAPP's effective date and are independently non-actionable. Okay, keep that in mind. So she's saying basically that there's a lot of statements that are non-actionable that that the judge hadn't even heard yet. But and then bucket 1 consists of 77 statements first pleaded in the original complaint. 23 have already been dismissed by the court and cannot be revived by the repleading. And I think that might be the strongest argument she has. So she might get away with those 23, but 34 survived summary judgment and require the court to now perform on a complete record the individualized malice analysis the Constitution requires. Okay, and then she made thank you so much. Susie Flies says, bye, Katie Joy. We won't miss you. Thank you, Susie Flies. I appreciate you so much. And that's a very true statement, right? Very true statement. I will bet working with KJ after KJ is going to Jennifer seeking career change too. She might. But so those are the buckets. So basically she's saying, thank you so much, Susie, that they all fall into these categories, and this is what, okay? And she makes it very broad. But remember when she had the filing before this, she had made like that huge, that huge graph, and it went through every statement, and it was color coded, and it said like, this is opinion, right? And all this. But this one, she was very broad with it, and we said that. So there's a lot of things that we talked about. So now let's go ahead and get into Lord have mercy. Let me see here. Hold on. This one. I got to close a bunch of stuff. I see what happened now. Okay. Let me take this off the screen. And let's get into it. We're going to go by pretty quickly, but as I was saying, so back to he basically said that these buckets, okay, so that's why that's what I'm going to talk about, these buckets. He was like, look, he points out that I think it's like 3 of the buckets contain anywhere from 7 to 113 statements. And just like simply placing these statements into categories is not enough to establish that each of those individual statements should be dismissed. But remember before, she completely like was going over each one of the statements individually and saying, it was an opinion or it was sourced, or I forget all the other ones, right? But also, y'all, what gets me, which makes me laugh, is that he says Katie Joy actually filed this this motion a day late. Okay, so you did, SD. SD just got a surprise visit from your daughter. Enjoy your time with her, SD. That's lovely. Hey, Barbara, did I acknowledge you? Did I say hi? So he says this was filed a day late. And not only that, look, this limit is 35 pages and Katie submitted 40. And we have caught her in that before. Remember, we've been like, wait a minute, she's exceeded this, but she was never called out on it, or she was never, like one of them, I think that she actually requested to be able to exceed the limit. And I think that was granted on one, but she's gone over. This is probably the second or third time. I say third, but I think one was granted to where she could. Okay, hang on one second. This is pissing me off. All right. Let me see if I can do it this way. All right. Are y'all seeing that? Let me make it bigger. That's too big. Oh no. Can we, if we do it this way, can we see it? Does that show all the, it does. Okay. So we're going to do that. We're going to do it that way. Okay. Y'all. So he says you filed it a day late. Not only that, you went over the page limit. And because you filed it a day late, you shortened our time to respond by a day. And you did it while you knew there was a change of counsel. So they're basically saying, Judge, we want you to absolutely delete the last 5 pages of her filing. And we'll get to that. Obviously, they oppose the certification for appeal. They give their reasons. They reject the 212 statements. Oh, the ones that, so they reject the 212 statements are too many arguments. So Katie Joy's argument is 212 statements are so many. I've said, I'm sorry I said so many shitty things, but if the jury has to deal with all that, it's way too much, Judge. Like it's just going to overload the jury, and they gave a jury questionnaire thing. And this guy is like, we'll sort through that. Like, that's our job. That's their job. Right. But as you're going to see, it's very, very clear that 7M is saying, all right, court, just deny Katie's special motion for expedited relief and deny her request for attorney's fees and costs. Right. And for me, the biggest argument here, I'm interested in the whole public figure argument. But for me, I think one of the biggest arguments is that 7M is repeating that the court has already twice, not once, but twice, has found that certain statements present genuine issues, right, for a jury. And including actual malice, that this court has already twice found that. And they're essentially telling Judge Willis, like, look, you already decided these issues. Katie hasn't brought new evidence that changes those decisions. Don't reopen them. Don't reopen them under a new, like, procedural vehicle or whatnot. You know what I mean? So it's a lot of sheet to shovel. Yeah, she's not only is she calling the jury dumb here, it's like she's calling the judge that. Like, oh, you're gonna be so overwhelming. Just like in that video that we watched recently, that is included in these 212 statements. And, you know, there's so many that I know Katie wished she never said probably at this point. But one of them, she said, oh, 7M is just filing so much stuff and throwing it at the judge to confuse them. And the judge gets it wrong all the time. And she was saying this. Sorry if I make a bunch of noise. Hold on. She's saying this by saying, oh, look, you know, because the judge granted her reconsideration for summary judgment. And Katie Joy's like, see, look, told you I was right. This judge is going to find that I'm right because 7M is just filing all this stuff to confuse the judge. Hello, Shauna. Robert Shin, I don't think it's a public figure. He doesn't have a social media presence. The Derricks do. And you know what? What I've learned through this, Christina, we're all going to learn. We're all going to go through this together. The way he describes it here makes it so perfectly clear. Okay. I love his style. And, you know, I just think that this is I think it's so bad for Katie Joy. But I think the biggest argument here is like, look, you've already under two different situations. Summary judgment has survived twice, not once, but then also in consideration. So I think that's the biggest, for me, that's kind of the biggest argument I'm seeing here. And also it's important that 7M, you know, they do not concede that the anti-slap, every time I want to say UPEPA, I feel like I'm going to get tongue-tied, but that is, you know, that's their anti-slap. So they do not concede that it applies simply because the second amended complaint was filed in 2026, right? They're drawing a distinction between adding statements and factual allegations and adding a new cause of action. And what they're saying is there are no new causes of actions added here. Katie Joy's arguments, y'all hit that thumbs up, please. If y'all are in here, please hit that thumbs up. You know, there are no new causes of action. Everything relates back. We've not added anything different other than more defamatory statements that we believe are defamatory. And she stated as a fact. And if you've already you know, if it's already been found by a court twice that certain statements present genuine issues and that a jury needs to determine, there's no difference here, right? So they're obviously asking Judge Willis to deny her entire special motion for expedited relief. And then there's some other issues he has with that, saying that what she filed, I believe, is incorrect. We'll get through that too. So basically, as we know, as we saw in Katie, she's trying to use Minnesota's newer anti-slap law basically to get another bite, right, at the issues the court has already considered. This court has already allowed them to proceed. They've already considered it. And Katie Joy's like, no, but Judge, one more thing. And this guy is like, no, you don't get a third time. Let's hope third time's not a charm in this situation, right? Mommy's going through something with the pumpkin. Oh, goose. There's spike in sales of wine in Hanover. All right. So let's look at these arguments that they are going with. All right, y'all. Let me pull this up. All right. Hold on. I got to make sure that I'm. All right. So as we saw, basically they're saying all the causes of action in this case were asserted before the effective date of the act of May 25th, 2024. And Katie's argument and the alternative are subject to the law of the case and are otherwise unsupported by admissible evidence. The relevant facts, as we already read, but if you were not here when we did, this lawsuit is about a social media agitator masquerading as an investigative journalist, in quotes, who has ruined the lives of plaintiffs by manufacturing false accusations against them and posting them on the internet for clicks, revenue, and attention. The court is well aware disseminated these allegations with no factual or evidentiary basis. They have lost protection under the First Amendment. Yeah, she's been trying to manipulate the anti-SLAPP since it came into effect. And it's funny because it's funny because it was pretty much right when the docuseries came out. Okay, the docuseries came out May 31st of 2024. This anti-SLAPP came into effect May 25th or May 24th. And I guess Katie's like, I'm covered now. So that's when she started just going rogue, y'all. And that's when everything was just, as the court knows, above captioned matter has a detailed history with numerous motions for both parties. In the First Amendment complaint, plaintiffs asserted 9 causes of action against defendants, all stemming from defendants' false allegations and harassments on various social media platforms. They remind that remember the First Amendment complaint contained 85 statements. And summaries of statements made by Katie Joy on her social media. And they remind that Katie Joy filed a motion to dismiss originally, and it was denied. And so here we are, 4.5 years later. You wonder if Katie Joy advocated for the anti-SLAPP in Minnesota. Probably. I love this lawyer in just one sentence. I mean, this whole thing is so beautiful. And I know it's going to be like, you're so weird. I get these assholes in my comments that want to tell me, but here's what gets me. They're not willing to read this. They're not willing to look at Miranda and James and how their lives have been ruined because they're saying it was by Robert Shin. And, and we're all saying, no. This is Katie Joy's narrative. Every time Miranda tried to say something, she was silenced. The court granted Katie Joy's motion for summary judgment in part and denied the motion in all other respects. Defendants brought a motion to reconsider with respect to all other portions of defendant's motion for summary judgment. In deciding the motion for reconsideration, the court dismissed additional statements, but indicated that amending the complaint would be appropriate. And then plaintiff started the Second Amendment complaint on June 4th. Finally, on August 11th, Katie Joy filed this motion and yet another attempt to dismiss plaintiff's legitimate claims. Okay. Katie Joy is trying to say that none of her statements are actionable. And can y'all hear me? Did I go silent? Can y'all hear me? I feel like, okay, you can hear me. Thank you, Shorter Cook. I appreciate you. So let's start with their argument. Plaintiffs, Minnesota, EPA, they're anti-SLAPP. So plaintiffs' motion is barred by the anti-SLAPP's saving clause. Okay. Didn't go silent on your end. Okay. I couldn't, sometimes I can see when I'm talking, when it moves, but I need to take this off the screen. And so then I won't be able to tell. Yeah, dumb fucks in your comments yesterday saying KJ has reporter privilege. You know, balls. I'm sure you get way more than I do. I don't know. I mean, I'm sure that YouTube gets certain shit, and Instagram, Twitter get different stuff. I kind of stopped even engaging over there, so I don't even know. The fact that she can even call herself a reporter bothers you, Skynet. Same here. And we're going to talk about that too, because I still have questions about how that's going to play out. They haven't really addressed that other than that she masquerades as an investigative journalist. Okay. Hold on. What is going on? Y'all, I'm about to lose my shit over here. Hang on a second. It's showing something on one end, but then it's doing something different on the other. And I'm lagging. This is so okay, y'all. Now I'm having issues over there. The curse of KJ. I'm telling y'all, I don't know what's going on. Hold on. Y'all give me, hold on. Let me see. Hold on. I'm trying to, it's got me all fucked up is what it's got me. Hold on. It's got all these new tabs opened. If I cut out, y'all, because I don't know which one I'm on. If I cut out, let me know somehow. If I have any of my mods in here that can text me. I know I've got a couple watching in the bushes listening. Okay. Hold on. I need that open. I got to figure out which one I'm showing. Okay. I'm not showing that one. I'm showing this one. I think I figured it out. I don't know what happened earlier. Okay. Hold on. I got to figure out which one I'm in. I think I'm in that one. If you were KJ, you'd be begging for forgiveness and going on my channel and just admitting wrongdoing. You know what? Is that even, there's no way she would even be able to do that, would she? Okay, I think I've got it all sorted, y'all. Hey, Helen, how are you? All they have to do is play the News Nation interviews. Y'all, I played the one the other day, and we're going to go through the other one whenever we get to it. Hey, Pink Moments. Yeah, but she says, Balls 2.0. I appreciate all you do. You keep me updated. You make me laugh. Yes. And if there's anything that sometimes I'm like, oh, I wonder if something happened, I'll go on Instagram and look. But hopefully, I wish we had more people covering it, right? I know that Renelle, she was in here earlier, and I know that sometimes she'll cover her too. But I think she's just like, oh, she's, the only thing I talk about is the lawsuit. I can display them. I don't know what happened, but it opened. I'm not kidding y'all. I had like 25 windows open, and they were all the same shit. So I didn't know where I was at, but we've got this now. We got this now. We're good now. Thank you, Skynet, for gifting another Southern Mutton membership. I appreciate you so much. Pink Moments, welcome to our members. You are a Mutton's cousin. Hey, Opal. Okay, so the argument, clearly, is that the anti-SLAPP is barred by the savings clause, and says they say it's not applicable to this action, which was filed on March 31st, 2022, over 4 years ago, okay, before the anti-SLAPP existed. And the anti-SLAPP, again, it's their UPEPA, but it's their version of anti-SLAPP, and I feel like I get tongue-tied if I say otherwise. Only applies to a cause of action that is asserted after May 25th of 2024. So all the causes of actions are the same, y'all. No, she'll never apologize or admit wrong, Goose. I agree. You know, none of the causes of action changed. The only thing that's changed, y'all, is that Katie Joy could not shut her mouth, and 7M had to add over 113 more statements, or around 113 more statements. Okay. And then they go into the, you know, how that applies. You can get these documents. I'm going to put it in the chat. You can get the documents here for anybody that is interested in reading them, because I'm going to kind of breeze through them. Okay. So you can pause to read it here. I will probably do a video on this. I know some of y'all, hey, Mama Celeste. I know some of y'all prefer whenever I do a video. So, and some prefer the live stream. So if I have time, I go out of town again, y'all. That's another thing. I'm going out of town. I'll be gone next Tuesday. I probably will be able to make it back Friday, but I won't be live Tuesday. But I'll let y'all know if I will not be able to go live next Friday. So I don't know if I'll be able to get a video together, because I'll be gone enjoying my time and touching grass, which is something Katie Joy needs to do, especially in this kind of situation, right? So here plaintiffs raised 9 causes of action against defendants in the First Amendment complaint, and reiterated 8 of those same causes of action in the Second Amendment complaint. We've talked about that. Cause 5, which was intentional infliction of emotional distress, they went away with that. So there's 8 causes of actions. Nothing has been added here in this Second Amendment complaint other than statements that Katie Joy made. And it says the 9 causes of action that plaintiff's First Amendment complaint were all asserted on April 7th of 2022, more than 2 years prior to May 25th, 2024, which is when the anti-SLAPP came into play. Plaintiffs did not add any causes of action in their Second Amendment complaint. Okay. So they're saying that, therefore, the anti-SLAPP does not apply for that purpose. Okay. That's one purpose. Also, Katie Joy cannot move to dismiss statements that have already survived summary judgment. And they say, by Katie's own admission, these particular statements, there's a lot of them, all in bucket 1. Okay. I love how I really feel like he's just laughing at her buckets. Like, I think that, like, it's just, I bet you every time he had to write bucket number 1, bucket number 2, but I bet he got it. I hope he got a giggle, right? She says they've already survived summary judgment. Katie Joy has acknowledged that. So the court, and then this is what we were saying. The court has already twice, not just once, twice, found on defendant's initial motion for summary judgment, and again on their motion for reconsideration, that a reasonable jury could find them false, defamatory, and that they were made with malice. Defendants cannot move a third time to dismiss these counts under the law of the case doctrine. So basically, he's like, good try, but we're going to shut you down there. No, we're going to shut you down there. We've got more. Okay, let me see. Helena, are you a mod? Are you saying because you're a mod that you accidentally hit somebody? Are you a mod in someone's chat? Because if so, would you mind being a mod here? And again, the only thing I ask of my mods is just to silence or to mute somebody if they put out personal information. or if they're going against another creator, or if I don't care if they're being derogatory towards me, I don't give a shit. But if they're saying stuff about Miranda and James or other creators that cover this, I just want them. I didn't know that, Helen. Hold on. That's not what I meant to do because I'm not in the right thing. I hope you don't mind. I just modded you, Helen. And again, it's fine if you're here. It's fine if you're not. But if you're here and you just see, I don't want any doxing in the chat, no personal information, and I don't want anybody going against the plaintiffs in this case or any other, anybody else that covers it the way that we cover it. Okay, back to what we were saying. The law of the case doctrine provides that when a court decides a rule of law, that decision should continue to govern the same issues in subsequent stages in the same case. So good try, Katie Joy, but it's all the same shit. You're trying to make something of something that's not there, right? So good try. The court has already found twice on defendant's initial motion for summary judgment and again on defendant's motion for reconsideration that a reasonable jury already went through that. So you don't get a third shot. And here, defendants seemingly seek a third attempt at summary judgment on statements 1 through 5, and then all these other statements, all in defendants bucket 1. Those statements have already survived a first motion for summary judgment decided on June 23rd, 2025, and a motion for reconsideration, which was decided on December 17th, 2025. In the court's order for defendant's motion for reconsideration, the court made detailed findings with respect to the appropriateness for a jury to decide defendant's liability with respect to these statements. Okay, look at all these statements. And then they quoted what the court found, and they say specifically the court found, and this is straight out of the ruling. It is not this court's province to determine whether the statements are true or false. Additionally, a reasonable jury could determine the statements harmed 7M's reputation and lowered their estimation in the community. Okay, that is what the jury needs to determine. If they say that Katie Joy's statements harmed the plaintiff's reputation, lowered their estimation in the community, that's defamation. And as reflected by the alleged significant financial impact 7M's reporting had on 7M. Furthermore, the evidence in the record could support a reasonable jury finding. So, either that plaintiffs have shown actual malice by clear and convincing evidence, or that plaintiffs have not. Because Ms. Paulson's state of mind is relevant to whether or not she acted with malice, the court finds summary judgment is not appropriate on this allegation. So all of this has already survived summary judgment. They're saying, look, we don't need this again. But look, if you notice too, they've already established, or they're saying that they believe the court has already established in certain statements that survive summary judgment that the jury would determine that they were made with malice. And keep in mind, we're about to see where 7M argues, look, actual malice only applies in defamation if it's regarding public figures. But we've never said we're public figures. In fact, we are at the stance that we're private figures, and we're going to look at that. So the fact that I think that's why I'm wondering if this was strategy on Amber Stavik's part, that she didn't ever really address and make such a big deal about them not being public figures, because they wanted to make sure, I guess, that they were backed with the actual mouth. Give me a second, y'all. Good grief, that came out of nowhere. Holy cow. Woo, that was the biggest itch in my throat. Katie Joy's devil's telling me to shut up, burn your throat, stop talking, lady. Make his wood guitars. Oh, balls. All right. So the court's prior to decisions to allow these claims to proceed should be left untouched. Okay. So I was saying before I got on this, before I started choking on myself, I'm wondering if it was strategy on, I'm sure it was strategy on Amber Stabbig's part. They didn't want to really sit here and fight whether they are public or private. And my guess is she was probably going to do it at this stage anyways, because as we've seen, they're able to say, look, this judge has already said, not once again, but twice, it survived summary judgment. Okay. And so therefore, if the actual malice standard comes into play, they've already said, yeah, malice. If this judge agrees, once we get to this point where he says, look, we're not public figures, we're private figures. If the judge agrees with that, the actual malice standard doesn't even apply. So then she's really screwed. I mean, she's screwed no matter what, in my opinion. So, again, all statements relate back to original complaint and are not time barred. So he says that all statements included in the Second Amendment complaint relate back to the original complaint, and plaintiff's claims under the First Amendment complaint and the Second Amendment complaint are identical. Okay. Plaintiffs only provided additional and more specific factual allegations about defendants' defamatory statements and bad conduct. Okay. So you kept yapping. You didn't shut up, and you expected to say, oh, now it's going to be covered by anti-SLAPP. Why? All your statements relate back to the original. They're not time barred. You lose at this argument. He says that this position fails because these statements are the same claim originally raised in the complaint, and the conduct at issue is identical. The Second Amendment complaint merely provided additional factual allegations under the same claims. Thus, the additional facts are not time barred, pursuant to Minnesota Rule of Civil Procedure 15.03. Whenever a claim of defense asserted in the amended pleading arose out of the conduct, transaction, or occurrence set forth or attempted to be set forth in the original pleading, the amendment relates back to the date of the original pleading. Okay. So you're saying that all these things they're separate claims, blah, blah, blah. And then he's saying, no, they all relate back. Nothing has been changed other than your shitty conduct, your defamatory statements, we believe are defamatory. Courts have found that when an amended complaint sets forth the same causes of action on those same facts as the original complaint, the amended complaint relates back. And he cites this case. Okay. So you can see why I was saying earlier that it's like, to me, his biggest thing is no. You're not getting a third attempt here. Sorry, y'all. I'm going to prevent myself from gagging again. I don't know what that was all. Here, the Second Amendment complaint contains 8 of the same causes of action as the First Amendment complaint. Okay. And the Second Amendment complaint merely adds additional facts and specificity about the defamatory statements and provides additional context surrounding the defamatory statements made by Katie Joy. Notably, the subject matter, methodology, and audience of the additional statements put forth in the Second Amendment complaint are substantially similar or identical to those set forth in the Amendment complaint. There are no changes. Nothing's time barred. And he's saying your argument fails. Katie Joy kept saying, not that her statements aren't actionable. And I think Amber Stabbig shut her down on that a bit. This guy's completely shutting it down. Like I said, handed over the baton. And I think this is the beginning of the end for Katie Joy. I just don't see her winning this argument. I don't see her her motion to dismiss. I don't see that being granted. I almost don't even see, I almost see it being dismissed in full. Like, I don't even know if she's going to grant it in part after reading this. The cause of action and facts in the Second Amendment complaint all relate back to the First Amendment complaint. Therefore, the court should deny Katie Joy's motion for judgment on statements 78 through 92. And he says, he says that about, again, these are Katie Joy's bucket numbers, right? Her bucket statements that I guarantee you, they got to laugh at the word bucket. Yeah, Helen, this lawyer's brilliant. She should be worried. Agreed. I agree. That's how I feel too. Oh, that TikTok psychic is another rabbit hole for real. I have all the videos that she had put out on TikTok somewhere. Unreal. Yeah, the way Amber clarified the complaints made it very clear. And sometimes Amber, the way that she wrote things, it's hard for like the layman to really kind of sometimes read it easily. This guy makes this so freaking easy. Like he is just like putting her down, shutting her down so easy. It's just like boom, 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 just another day in the office dealing with a dipshit attorney. But this is a very serious situation. This is very real. And he's saying, you have ruined, defendants' actions have ruined my clients' lives, their reputation, their businesses, their financial, everything financially about their lives. I think it's going to NKJ. Ding, ding, the witch is dead. Pink moments. She still hasn't shut up, Christine. Didn't she move to some other country? Okay, plaintiffs are not public figures. Here's his argument. Plaintiffs are not public figures, and the statements do not constitute matters of public concern. We're going to read this together. And I think for all of us in here, this is absolutely going to give us a clear understanding of public figure versus private figure in Minnesota. I think a lot of the stuff that I've read regarding his other civil lawsuit in LA, their standards are different. Okay. So let's look at how he explains why he feels that the plaintiffs are not public figures. Okay. And because of that, the statements do not constitute matters of public concern. So this is great, y'all. Actual malice is an essential element in a defamation claim only under limited circumstances, namely when the plaintiff is a public official or a public figure, or when the defamatory matter involves an issue of public concern. Okay. And remember, again, in order for defamation in Minnesota and pretty much everywhere else, if it's against a public figure, you have to prove actual malice. Okay, we've talked about that. And that's what he's saying, like actual malice is essential in defamation claim only if a public official or public figure is involved, right? Only when one of those limited circumstances applies must the plaintiff demonstrate clear and convincing proof of actual malice, that the defendant acted with willful or reckless disregard for the truth of the matter published. And we have to keep in mind all the filings that Amber Stabig filed. She really, really, in my opinion, proved all of that. All right. Where am I? I mean, I believe that she absolutely proved that Katie Joy, acted with reckless disregard for the truth. I mean, I think there's a lot. I mean, and when we go back and as we've looked at these statements, y'all, where we've gotten to with those statements out of the 212, like I said, we're not even really to the bad ones. When we watched her interview, the very first interview the other day that she did with News Nation, when we rewatched that, y'all, that alone will bury her, in my opinion. Minor internet celebrities are not public servants. They don't live off the public trust. And, I guess because it was never really addressed in here, I assumed that the court, I don't know. The court has to determine, okay, y'all, the court has to determine whether they're public or private figures, okay? And then we're going to see the three types of public figures. But the court needs to decide this. They haven't determined yet. So I'm really curious to see when this goes to the trial, if it's going to be that they're public figures, all of them, some of them, or none of them, and that they're all private. On the other hand, when the plaintiff's a private figure and the statements do not relate to issues of public concern, as in the case here. Okay, so he's saying they're not public figures. These statements do not relate to issues of public concern. So Katie can take that and shove it up her ass. The plaintiff need not establish actual malice in order to prevail on his defamation claim. So if they get their way on this and they prove, which look, y'all, the law is the law. He's stating the law. We'll see if this judge agrees. If this judge says they're all private figures, then this jury won't even have to determine actual malice. Hey, Bobby Flies. They proved that malice either way, right, Goose? And I think that's obviously what Amber Stavig was going for. Like, look, let's get to the top. Let's make sure our asses are covered completely. If we have to prove actual malice, let's start here and let's start doing it. And then if we get to the point where we can prove that we're not public figures, then that goes away. Hey, Sunshine and Rain. That absolutely happened. It was actually her goal, says True Ball of Wax. And then here they say again, in its order dated June 23rd, 2026, that was the initial ruling on the first summary judgment. Okay. This court stated that 7M seemed to concede that the actual malice standard applies to this case because they argue they have satisfied the actual malice standard in their pleadings. Plaintiffs have not conceded that they are public figures, however, or that actual malice standard applies. Okay. So as a result, defendant's application of the actual malice requirement is erroneous, and its special motion to dismiss plaintiff's defamation claims must be denied. Plaintiffs are not public figures. The U.S. Supreme Court recognizes three categories of public figures: involuntary public figures, or those who become public figures through no purposeful action of their own. Okay, so involuntary public figures, or those who become public figures through no purposeful action of their own. All-purpose public figures, those who have assumed roles of a special prominence in the affairs of society with such persuasive power and influence that they are deemed public figures for all purposes. And the third is limited purpose public figures, are those who are so classified only by having thrust themselves to the forefront of particular controversies in order to influence the resolution of the issues involved. Okay, well, that sounds like Katie Joy is a limited purpose public figure. Okay, so Katie Joy being a public figure, it doesn't really matter in this case, but nonetheless. And he argues none of these categories accurately describe 7M's status in society with respect to the alleged controversy that is the subject of defendants' defamatory statements, making them private figures not subject to the actual malice standard. Okay. Plaintiffs can easily be ruled out as involuntary public figures. Excessive coverage by the media of private person cannot render that person an involuntary public figure. And both the U.S. Supreme Court and Minnesota Supreme Court have noted the rarity of involuntary public figures. Okay. So they're saying not only is it rare, we just don't fall into that category. Minnesota Supreme Court specifically rejected the proposition that the media can unilaterally create a public figure simply by excessively covering them in the media. And so he's arguing, look, you made us this. You are the one that put us into into this public situation, this controversy, this dispute. We did not put ourselves there. We did not create this. This did not exist until Katie Joy came around. Katie Joy thrust us into this. And by Minnesota's standards, that, we saw how the three types of public figures, and he's saying we cannot be included in any of those. We did not put ourselves there. Just because Marina James were a presence on social media does not make them a public figure. And his argument is just so strong. And it's something that I don't think we really focused on that much on this channel because we hadn't gotten there yet. Right. But Katie Joy says, and she has declared that 7M, all of 7M are public figures without adequately analyzing, or establishing that proposition, I guess. Right. They argue. And so here they're arguing that none of the three relevant categories of public figures apply. Like, we're not involuntary public figures. We're not all-purpose public figures. And we're not limited-purpose public figures. They did not, again, they're saying, we did not thrust ourselves into a pre-existing public controversy. Katie Joy's statements and those statements themselves generated the controversy and pulled the plaintiffs into the public eye regarding this controversy. So, were James and Miranda in the public eye? Yes. Were they in the public eye for this controversy? No. Okay. So nor can plaintiffs be categorized as all-purpose public figures. That status is reserved for celebrities and prominent social figures. Okay. And finally, plaintiffs cannot be considered a limited-purpose public figure. To attain that status, a party must participate in the controversy in question. Okay, so I think this is very important, y'all. Okay, I think this is very important because I think this shows how Amber Stavig really, really set this up, handed it over to this new firm beautifully. Okay. I think that 7M obviously has been very smart, extremely smart, right? Smart in the sense that they didn't respond, y'all. They did not participate in any of this. Like, if they would have participated in the Netflix docuseries, which they wouldn't have done because it was stupid in itself, because it was one-sided, it would have been stupid in itself to put themselves there, because then they're acknowledging it. People be like, look, they're there. Anytime you try to defend yourself in something, people assume guilt, right? Plus, they were in current litigation with so many people that were involved. Katie Joy, the other two bloggers, they're all the archival consultants, right? And you've got the two other sisters that were a big part of this docuseries that they're in current litigation. And so they never, ever responded. They never put themselves in that position. And I think that was pure strategy. There's 7M. Robert Shin listens to his legal advice. The advice that he gets, he takes clearly. So whether it was from Amber Stavig, whether it was from some of his counsel in LA, whatever it may be, they did not react. They did not respond. They did not become part of it. And whenever I read this, I was like, well, holy shit. Wow. It's that simple to explain. Look at how easy he makes this sound, y'all. So again, not a limited purpose public figure, because in order to attain that status, that party must participate in the controversy in question by thrusting themselves into the vortex of public controversy to influence its outcome. They didn't respond. They did not react. They did not participate in the docuseries. They did not participate in another one to counteract them. They did not put themselves in any part of Katie Joy's created dispute. That she now says, oh, it's a public controversy. This is public controversy. And from the very beginning, 7M has been saying this is a private family matter that Katie Joy has turned into a huge public controversy. A huge public dispute. It's a private family dispute. You turned it into a public dispute. And they're saying we were never a part of that. We never wanted a part of that. You made us a part of that, but that does not make us public figures. Hey, Bobby. Yeah, by this definition, that makes Katie Joy a public figure, which, I don't think really matters at this point. My whole thing is, I've said, and I think I've said it incorrectly, that, well, maybe the judge is just leaving it up to the jury to decide if Katie Joy's a journalist. I don't know. I'm still trying to figure that part out because it doesn't really it's not a big role. I guess they're just going to say are they going to say, no, she's not a journalist? Well, if they say that, well, then the ethics, what is the jury going to do regarding journalistic ethics and integrity, right? Right. Private family matter until the Wilkins made it the public business. That's on the Wilkins. That's on them, right? Not 7M. You bet Katie Joy will toss him under the bus Swanson style. I think so too. I could be wrong. I don't know. I think that's a very good possibility. I mean, if we look at her patterns and look at her MO. Yeah, Katie couldn't even find a photograph of Robert Shinn. Remember that video? She's like, he doesn't want to be seen because he's hiding something. No, bitch, he don't want to be seen because he's just not a public figure. He's a pastor in a church. He has all these businesses. But look, I'm from a very big city. Does that mean these multimillionaires that run several companies that, yes, legitimately have several LLCs, because that's not a fucking crime, Katie Joy. It's called business, right? Are they all public figures? Should I know who they all are? No. If they got into some matter of public dispute, hopefully I would be smart enough to go, wait, there's two sides to every story. What's their side? They're not speaking, but somebody's accusing them of X, Y, and Z. So I think their argument's very strong. The Wilkins used Katie Joy's platform to air their grievances. I think, well, yeah, they aired their grievances. They had a very large viewing themselves, but Katie Joy was the one that was going to extend it out and spread the narrative of the cult. The cult has their precious baby girl who needs to come home to mommy and daddy. Yeah, she'll blame everybody else for this. That's her track record. And again, y'all, that's my opinion. Y'all can speak it how you want in chat. I agree with that. That's my opinion as well. And I say, I look at everybody's patterns. I look at everybody's past. It says that she will. No matter how flat you make a pancake, it has two sides. Exactly. Robert doesn't have 800 selfies like KJ does. She hasn't gone, now y'all, she hasn't been on film lately because she's scared. Even though she's going to taunt Robert Shinn and call him Roberto, make fun of his height and all those things, she's scared for her life, y'all. I wonder why she really won't show herself. I know the injustice of it all, balls. And the thing is, people like you and me that talk about this, we get all these dumbasses and assholes that aren't willing to just stop and look at the whole thing. Have I ever said, oh, Robert Shinn, you're my hero? No. Have I ever said, Robert Shinn, you're a piece of shit? No. Have I ever really given a perspective? No. We're looking at the truth here. Just because you don't like somebody does not mean you get to do these things, Katie Joy. It's against the fucking law. And you get sued for it. And then you get a super lawyer like this up your asshole for the next, however long it's going to be till this ends. You did this to yourself, Katie Joy, and it's fucking hilarious. And I laughed my ass off, and I'm going to continue laughing my ass off every time I see a filing from this brilliant guy. Period. End of story. You're a dipshit. You and your attorney. Suck balls. All right, rant over. Let's carry on. So three factors must exist to categorize plaintiff as limited purpose public figure. public controversy must exist that was not created by the alleged defamatory statements. Okay. Here, clearly, this public controversy, according to 7M, was created only by alleged defamatory statements. This was created by Katie Joy. We have been saying this. I've been screaming it from the rooftops. This is Katie Joy's narrative. The plaintiff must play a meaningful role in the controversy, and the alleged defamatory statements must relate to the controversy. Okay. It's very interesting what they do here. We're going to get to it. They obviously compare to another case, and they say no public controversy existed here prior to the defamatory statements. So that's, I'm not even going to get into their case study. In this case as well, that they're using this case study. To the contrary, plaintiffs were dragged into the public eye involuntarily on a purely private matter between Shin and his business and religious followers. Okay, sorry, I had that wrong. This case, plaintiffs were dragged into the public eye purely by private matter between Shin and his business and religious followers. At the very least, the question whether plaintiffs are public figures introduces issues of fact, which defendant have left unaddressed in their memorandum. So, in addition to all this, you didn't even argue it, Katie Joy. You haven't argued how they're public figures. Where's your argument on that? None of the statements at issue regard matter of public concern. Defendants conclude in the memorandum, again, without any authority or analysis, that the statements at issue are a matter of public concern. Speech regards a matter of public concern when it can fairly, hold on, y'all. My eyes just crossed. Everything went blurry. Speech regards a matter of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of general interest and of value and concern to the public. So, Katie Joy is saying all this is public concern. He was raided. That should be a public concern. I'm really curious how they're going to argue that aspect of it. Are you out of here, Skynet? See you later, Skynet. Have a great rest of your day. KJ has a way of sensationalizing things that do not need to be. Yes, I mean, seriously, that is so true. All right. So what's the public concern here? What's the public interest here is what they're saying. Matters of private concern, on the other hand, are not subject to the actual malice standard on which defendants base their motion. Likewise, the anti-SLAPP law here does not apply where the defamatory statements at issue do not regard a matter of public concern. Minnesota courts consider the totality of the relevant circumstances in determining whether speech involves a matter of public or private concern. I cannot wait to see what the judge says about this. I'm just really curious. The content of the speech clearly pertains to a private matter. And again, Amber argued this from the very beginning. Katie Joy took a private family matter and turned it into a public dispute. All right, so I obviously found this very important. If you could type faster, you'd be able to chat. I bet she made serious money off of them. One of the things that 7M is requesting, along with whatever they'd be awarded in damages, they want, in addition to what they're awarded in damages, whatever the jury finds fit, if this goes to trial, okay, whichever way the jury is told to determine, okay, under each cause of action. They also request that every bit of money that Katie Joy made off of 7M, that they get every penny of that. All right, let's see. I obviously highlighted this for a reason. Defendants made over 200 statements about plaintiffs spanning nearly 4 years. Throughout the time, the overall gist of the statement remains consistent. 7M alleged that they acted in such a way with respect to their business. Oh, I'm sorry. Katie Joy alleges that 7M acted in such a way with respect to their business and religious operations that Katie Joy considered reprehensible, in many cases going so far as to accuse 7M of crimes, consistently using inflammatory language such as predatory, abuse, and pimp, and drawing outrageous comparisons to infamous criminals such as Jim Jones. Y'all. Hey, Susie Flies. Oh no, we got it all cleaned up. I guess that's better than having to do your clothes on a washboard every day, right? It still sucks that we got it cleaned up. Oh, I hope she has to hand it over too. Her lawyer's not fit for this. Shayna, I agree. She's so screwed balls, I'm telling you. My opinion as well. Inflammatory language such as predatory, abuse, and pimp. He hasn't even gotten to it yet, y'all. They don't even address the whole SA situation of sex trafficking, of all of his alleged SA, right? That he's a rapist. At the heart of Katie Joy's years-long crusade against 7M is their belief that Shin executed some level of control over his clients and operated a church that Paulson regarded as a cult. These are plainly private disputes, if they can even be regarded as disputes at all. By all accounts, Katie Joy was the only one raising concerns over plaintiff's business and religious activities at the time the statements were made, not the participants. Example, the alleged victims themselves. Okay. So, yeah. Kate, let's keep in mind, Katie Joy tried to say over and over, I wasn't the only one talking in the beginning, right? In one of her declarations, one of her affidavits, she says, I'm not the only one talking about this. I'm not the only one. And other outlets have talked about it. And they even used them as exhibits. The problem for me is when you look at all of that, they all follow Katie Joy's statements. The dates are all after. And they're all pretty much Katie Joy's narrative. Some even, hey, Blake, how are you doing, my friend? Good to see you. I'm glad you stopped in. I miss seeing you in chat. And thank you. After the live, please come back and leave a comment or an emoji. Also, hype this video if you're able to. It helps Southern Mutton get in the algorithm. Thank you, Blake. And yes, please give this video a thumbs up, subscribe, and ring that bell. Hey, Tessa. But then she says she broke the story. Yes, thank you. Get me back on track. Then she says she broke the story, right? First of all, which one is it? That's going to come back bite her in the ass. She said that after she thought she said that after she thought Robert Shin was going to prison. She said that when she thought that this was just all going to go away, right? What I find very interesting here is what they use next to compare, okay? And to me, I think this really helped me see it. And I think it will with everybody as well. So it says comparison should be made to Freeborg. Okay, so in this case, the Minnesota Supreme Court considered the defendant's statements a long thread of Facebook posts on the topic of sexual assault that specifically accused 3 dance instructors of quote unquote rape. Under the content form context standard of Mathner, and concluded that the predominant theme of the defendant's speech involved a matter of public concern, namely sexual assault, in the context of the hashtag #MeToo movement. Okay. So we all probably remember that movement. It's gotten a lot of kickback. There was a lot, it came through, and then, so if familiar with it, great. If not, okay. But it was a public issue. It was a public concern. So there was the hashtag #MeToo, right? That was a whole movement, remember? In considering the content of the statements, the court recognized that the particularized allegations against the 3 instructors represented a private element within the statements. Considering the statement as a whole, however, and especially the speaker's use of the Me Too hashtag, the court concluded that the defendant's introductory commentary, feeling fierce with all these women dancers coming out, so eerily similar to Katie Joy, right? Suggested that she was encouraged by other women speaking out about sexual assault in the dance community to reveal her own experience and to add her voice to the community conversation. So I guess in this case, she's accusing these dance instructors of rape. And she included herself in this hashtag Me Too movement. Okay. In reversing the Court of Appeals, the Minnesota Supreme Court established a discrete gloss over the content form context analysis. The predominant theme of the statements at issue controls the analysis, even if there exists some elements of the statement that favors opposite finding when it comes to public concern question. There's a glaring difference between Katie Joy's statements and those at issue in the Freeboard. The greater hashtag Me Too conversation was very alive and well in the community at the time that the Freeburg posts were made. And the court expressly concluded that the posts regarded a matter of public concern because they contributed to that conversation, even despite its recognition that the statements contained elements of a private dispute as to the 3 dance instructors specifically named therein. In contrast, there was no existing greater social conversation regarding the subject matter of Katie Joy's allegations at the time they were made. Instead, Katie Joy's statements became the foundation of a greater conversation. All right. Basically, they're saying, how is this a matter? How is this a public issue? How is this a public concern? Where is the dispute? Where is your hashtag other than hashtag sex trafficking, which I'm curious. I think that's going to be an argument. But where is he deemed a sex trafficker? Where has it ever been said? Where has he ever been charged? Where has he ever been even accused publicly? She keeps saying that that's what he's being investigated for, right? That he's being investigated for that sex trafficking. We don't know that. That is not what was said in the filings in LA. That's not what was said. That's Katie Joy's interpretation, right? And because she said it, everybody else said it. Then she goes on News Nation. News Nation said it, y'all. News Nation said, yeah, he's being investigated for all these crimes, and they include sex trafficking. If you, on my channel, that's the one thing that I focus on the most, okay? Because she's insinuated many times that Miranda is a victim of that. And the sad thing is, y'all, even if he's not charged, if it comes out and he's like, look, I've been clear to this, I was investigated, but they didn't find shit, the haters are still never going to believe him. And they're still going to believe that Miranda is lying and that Miranda is stuck in the situation and that she's doing X, Y, and Z. So KJ thought that that was evidence, yeah? I don't think Katie Joy could ever make it in like she'd have to, I think she's the type that has to work for herself. I think she have, I don't know. Yeah, I mean, she might have to get a real job after this. Katie Joy, listen, Katie Joy is going to keep doing Katie Joy shit. She's going to continue this regardless of how this ends up. Yes, do I think that Robert Shin's goal is to break her financially? Absolutely. She did it to them. Eye for an eye, I guess, but he's doing it the fair way. He's doing it through the law. Even though she's accused him of criminal activity, being a threat because he owns an arsenal of weapons. And I'm here to say, so what? Don't come to my house. You'd really call me a criminal, me and my husband. I mean, come on. Keep your opinions to yourself. Fucking leftist. Anyways, another rant. Sorry. Here, the predominant theme of the 200 plus defamatory statements made by Katie Joy is her disdain for and disapproval of plaintiff's particular conduct alleged therein, not a mere contribution to a greater social conversation. So she's making it a social conversation. They never did. Miranda's family came out with it. Katie Joy picked up that wand, ran with it. Her narrative was spewed. Every time that Miranda tried to speak up, she was silenced. Defendants have yet to even identify what greater public issue they purport their statements relate to. How is she going to argue that, y'all? Katie Joy, what is a greater public issue? What is the issue? What are you helping people out with here? Each statement is laser focused on 7M and their alleged conduct, and they clearly constitute Katie Joy's transparent efforts to smear their reputations at every opportunity. You can't say it any better. They do not constitute a mere contribution to some broader yet undisclosed topic of social and communal interest. What is she going to argue here? Because he's not been found guilty of anything, y'all. These are all accusations. Not only the accusations, Katie Joy has stated them as fact. Y'all, she's screwed. How do you get out of this? Seriously, how do you get out of this? It's crazy, y'all. They're saying, Katie's statements are primarily about specific allegations against specific people and their private business religious activities, rather than participation in a broader public debate. So we'll see where this goes. I cannot wait to see the ruling on this, y'all. Hang on. I got to catch myself up on YouTube here. I got sidetracked by my dog's in my lap, or he's trying to be in my lap, so I'm getting sidetracked, y'all. Now he's playing with his rabbit. Love you, rabbit buddy. Oh, I shouldn't have acknowledged him. Now he's like staring at me like, what? You want to play? Let's play. All right. Moreover, the hashtags defendants used in their posts do not implicate a matter of public concern like the hashtag #MeToo hashtag did. That's such a strong, that right there just really, it simplifies it, doesn't it? The way that this guy writes this, it's like, I think anybody of any level in the community can read this and understand it fully. Yeah, Katie Joy doesn't play well with others. She's proven that. She's proven it. So, I mean, I feel comfortable saying that. She can't, when is she, I mean, like, she'd get along with certain creators and it would all be a fallout. She throws people under the bus. I mean, Katie Joy is going to continue being Katie Joy. She's going to continue doing what she's doing. People like her will not change. She will recreate herself somehow, some way. And I won't be there for it because it's just frustrating as hell. I'm here for this lawsuit because it's fascinating to me. It's interesting. And I think that, I hope that this can serve as some type of, influence with this. Like, you cannot just go say shit because you don't like somebody. And then she undermined Robert Shin so badly. She thought, oh, he's not going to do shit. He can't afford it. Look at this. Look at this motherfucker. Okay. He is, not only did he come back when Amber Stavig decided to make a change in career path, not only did he just hire another attorney, he made a statement by hiring the best of the best. They don't get any better where he's at. Balls. Hold on, I gotta find that. That's so funny. Yeah. Hashtag you fucked, KJ. Yeah, is that a matter of public concern, Balls? What do y'all think? Hey, Mary. Excellent point, she says. Oh, another burn. Balls, you're on fire. Maybe Mr. Ella had to write it this way so Jennifer Moore could understand. He took it down to second grade level. Hey, thankfully he did, because we're all over here understanding now, right? The hashtags will get you, Katie Joy. And we cannot forget that this judge stated in a ruling that Katie Joy's hashtags are considered a part of her post. So it's interesting because he's saying, yeah, well, you didn't use a hashtag that was even worth a shit, Katie Joy, because there's not one that applies here. Nothing applies here as a social dispute, like a matter of public concern. You didn't have a hashtag that applies, but sucks to be you, because every hashtag that you used, several of them were defamatory, and we're using them against you. Yeah, she didn't even think, she literally said that Robert Shin wasn't going to show up in person at the hearing. Yeah, she's such an idiot. Can Jenny understand big words like defendant? Well, I don't know, Susie Flies, because in some of the filings, they claimed themselves as the plaintiff. Remember? She couldn't even get plaintiff and defendant right in some files. And that's a truth. I'm not stating bullshit here. That's just the truth. There are filings where they got plaintiff and defendant mixed up, where they called themselves the plaintiff. Oh yeah. What was the whole situation with the word affiliate? In the beginning, whenever they said any of 7M and their affiliates, and Katie Joy's like, I don't understand the word affiliate or some shit. I hope Roberto's eyes do stare a hole through Katie Joy in court. Oh, you think that bitch would call him Roberto to his face? I dare you, Katie Joy. I dare you, when you're on the stand, to look at him and say, well, Roberto over there is a sex trafficker. I dare you, Katie Joy, to refer to him as Roberto. I think, yeah, Helen. I'm 50-50 on it. There are people that absolutely believe that Katie Joy writes all of her filings. And then I'm like, I don't know. I'm 50-50. So yeah, I'm with you. I wonder. Yeah, she said, yeah, didn't she say she didn't know what the word meant? Like, yeah, like what? Narcs are cowards. Yeah, some are. I think the different types of narcissists. Katie Joy is the one that is cowardly. I don't know. Maybe she'll prove us wrong, y'all. Maybe she'll prove us wrong in court. Maybe she will look at Robert and call him Roberto. When defendants did use hashtags, they were specific to the private dispute itself. So the private dispute and the participants thereof, not a broader matter of public import to the community. Oh, that's where I'm going cross-eyed. Like the hashtag Me Too and sexual assault in general. So they're saying that she did hashtags like B-Dash. It's Miranda Derrick. She also did Free Miranda, right? Robert Shin, Pentecostal, 7M Films. Like, those are all private matters, they're saying. The context of the statements do not inform the analysis. Defendants cannot identify a greater social movement relating to their defamatory statements. Okay, so let's see how Katie Joy is going to try to identify a greater social movement. What is she going to come up with? There isn't one. I don't know. We'll see. We'll see what she says. Nor have defendants established a legitimate pre-existing public interest in plaintiff's private matters. So, Katie Joy sitting there going, it's a public concern, public dispute, all this shit. This attorney's coming in here and going, show us where. Show us where this was a public issue before you became involved. Now, Miranda's family did go public with it first and say all these things, okay? But did that create a movement? Katie Joy took it and created the issue. Oh, really, Susie Flies? That has to be awful. I was going to say, Katie, isn't that stupid to call him Roberto? But, right, Donna? I look, this is just me questioning. This is not me making any accusations or stating anything as a fact, okay? I question whether there hasn't been AI used in some of their last filings. I wonder if this new attorney doesn't question that as well. Because as you'll see, he's going to say in this filing that her references, her case study, or that she cites aren't even relevant. They don't even relate. They're not even of the same matter. And I've heard and I've read some things that people say that like the AI is sometimes it creates false case studies that don't even exist to cite. They're citing things that don't even exist. Again, I'm not saying that's what Katie did. I'm wondering if that's the case, and if this firm might feel that as well. And if it is, if they could prove it, I don't know if they could prove it. Could they prove it? And if they did, and they prove it, like what would happen? Again, this is just so hypothetical, so far out there. Don't quote me on any of this shit. I'm just wondering. I mean, she might not. They might not use AI at all, but I've questioned it. I truly have. You want to see how snarky she gets on the stand? Yep, gingerly. I'm curious to see how bold she is on the stand versus how she is behind the computer screen. And yes, I will be able to see that. That's all I'm going to say. KJ pushed the story when she was talking about other content. Yeah, I could see Robert calling Katie Joy what a sandwich to her face, though. I can too. When this is all said and done, maybe. I don't know. Robert Shin strikes me as one that he's only going to speak when he is spoken to regarding this, period. End of story. Defendants have not provided any substantive basis for dismissal under the anti-SLAPP. Okay. So basically they're saying she's proven nothing. And within that, Katie Joy's attempt to dismiss the bucket 1 and bucket 4 statements wholesale without devoting individualized attention to a single statement must fail. So having assumed incorrectly that the actual malice standard applies, again, he's like, look, it doesn't apply here, judge. All right. They're private. They're not public figures. They're private figures. So Katie Joy, having assumed incorrectly that the actual malice standard applies, Katie Joy argues that the court should dismiss all the statements that she has placed in bucket 1 and bucket 4 for lack of evidence that could support a jury's finding that plaintiffs acted with actual malice, as defined in the New York Times versus Sullivan, which has been cited in this case. What defendants ignore completely, however, is that the court has already declined this request by defendants on 2 prior occasions. A third bite at the apple will result in the same outcome. Okay? Screw your buckets, Katie Joy. Go piss in them. There's a hole in your bucket, dear Katie, a hole in your bucket. It's going to suck for you. On December 9th, 2024, Katie Joy filed a notice of motion and motion for summary judgment and supporting memorandum of law. Following a hearing on defendant's December 9th motion, the court filed its order granting in part and denying in part the parties' motions for summary judgment. In considering the actual malice issue, the court summarized the relevant evidence on the record, then held as follows. He's like, look, how many times do I have to tell y'all? You've said this. You've ruled on this. You've stated it survived summary judgment. The judge has already said this is headed to trial. Jury needs to determine. Just because we filed an amended complaint to add more bullshit, defamatory statements that you keep saying, that the defendant keeps saying over and over again, that are hurting us financially, have ruined, in their words, their lives, right? They take it straight from that ruling. Number 34, while Ms. Paulson, this is in the ruling, this is the judge says, while Ms. Paulson occasionally claims in her posts that the information provided in her posts are her opinion or are based on other people's allegations, she usually follows up those posts with hashtags referring to trafficking, human trafficking, sex trafficking, cults, and forced labor. These posts must be construed as a whole. When looking at each post as a whole, a reasonable jury could find that Katie Joy acted with actual malice. This judge has already ruled this. Again, in 38, the judge says again, a genuine issue of material fact exists as to whether Katie Joy acted with actual malice. As such, summary judgment is not appropriate on count 1. So therefore, count 1 did not survive summary judgment. And we know what that means. Go into a jury. Better get a bucket. Monty Python. Oh my gosh. Boy, that's old. That's old. Oh. So it's not a bucket. All right, see. Okay, well, we're going to call it a bucket. Is it a bouquet? Is that how they pronounce it? Is that what she's trying to say, really? Hold on. Let me put this up here so we can all be corrected. Hold on. Where are you at? Oh, wait. I got to really scroll down. All right. C says I'm saying it wrong. Damn it. Or is it bouquet? Wait. Is it really pronounced this? Or should I be saying, I'm saying bucket. Fuck it. What is that? What is it saying? Something in a bucket, fuck it. The court further finds that there is a genuine issue of material fact whether Ms. Paulson acted with actual malice in making her statements, as discussed in detail in count 1. So again, he's like, how many times do I have to say this, y'all? Seriously. This has already been ruled upon. Nothing changed other than your fucking client can't shut her mouth. Oh, okay. Y'all are citing. Okay, y'all see, look, this is why I hate whenever I go in and out of chat. There's times I'll just get in and say something. I'm like, oh, I'm totally interrupting somebody else's private chat. I mean, private like conversation. Sometimes I just need to see my way out. So just ignore me. The sandwich is going to be taken to the sea of bankruptcy. Yeah, possibly. They're just joking, says Helen. I see, now I get the reference. But I was like, holy shit, what if I, because I have people all the time going, you say that incorrectly. And I'm like, I do. I'll own it. I'll put it in that bucket. All right. Unhappy with the result, Katie Joy filed a request for permission to file a motion to reconsider and subsequently a notice of motion and motion to reconsider and supporting memorandum. And as we know, that was granted. But in part. So plaintiff's most recent motion asked the court to conduct the same tedious, repetitive analysis that has already completed twice before. And this is what the judge has kind of said recently, like, no, I don't need to take these questions to the appellate court. These questions. So remember, she denied those other questions that Katie wanted certified by the appellate court. So we're going to get into the ones that Katie Joy wants now. So let's talk about her bouquets. Her 4 bouquets. Maybe now we just call them bouquets. Unhappy with the result, right? Since she was unhappy with the result, and as we know, we've talked about this. Her filing. Remember, she came in and she was like, yes, this judge sees that I was right and that she was wrong. She's fucking stupid. She gets it. She finally sees that 7M just filed all this stuff and threw it at her, and she was too stupid to see. She was blinded by it. But I came in with my wonderful filing and said, look, judge, this is my motion to reconsider. You need to reconsider because you're a fucking idiot. I'm smart over here. I'm the one that writes all these things because my attorney, I'm smarter than her because, she's just a fucking family attorney, but whatever. So there you have it. So I need you to reconsider. So the judge said, okay, in my opinion, to prevent an appeal, let's just give Katie Joy this. It backfired. In my opinion, it backfired because the judge just said, okay, fine. You're saying this and this and this, but you're not giving any examples for it. You're saying that it's not definitive enough. So, all right, 7M, I'm giving you the opportunity to go back and make it more clear. Move this court to amend the complaint and make it more clear so Katie Joy can understand. It backfired. And now the judge is going to hear that Katie Joy said, yeah, see, the judge is so fucking, the judge agrees with me. But it turns out, no, Katie Joy, the judge did not agree with you. In fact, it was worse for you. Plaintiff's most recent motion asked the court to conduct the same tedious and repetitive analysis that is already completed twice before. Like, yeah. Though the allegations contained in the so-called bouquet 4 were not subject to the court's first two exercises of the actual malice analysis. The reasoning is the same with respect to all 212 statements because Katie Joy's state of mind is relevant to whether or not she acted with actual malice. Like, he's like, I'm just going to keep repeating it to you until you finally get it. Like, this is what the court said. Why do you think it's going to, third time's going to make a difference? And you said things that are worse. You're just trying to cover your shit. You're like a cat in a litter box. You ain't got no litter there, Katie Joy, because your shit's just all exposed. Ms. Paulson's state of mind is relevant to whether or not she acted with actual malice. With regard to each individual statement, both those have been previously ruled on and those that were more recently specified in the second amended complaint. In other words, you dipshit attorney, let me just put this in layman's terms. Like, was it Balls that said, let me just make this very clear to you and your second grade level attorney, because this court has already held that it will not dismiss the action on the basis of lack of malice. The addition of new alleged defamatory statements to the cloud of statements already alleging changes nothing. Don't you just see a little kid stick their tongue out like, take that, bouquet 1 and bouquet 4? With respect to the statements categorized in bucket 1 and bucket 4 and defendant's memorandum. And I do understand that that is a term used to categorize things in the legal world. But seriously, see, you had me thinking I was mispronouncing it. Oh, that's funny. Defendant's memorandum and the alternative, limited discovery under the anti-SLAPP, is appropriate to produce evidence to establish actual malice. Defendant's attempt to dismiss plaintiff's defamation claims on all 212 defamatory statements based on alleged pleading defects must fail. Okay. According to Katie Joy, 7M satisfied the court's directives contained in its December 17, 2025 order, but somehow its complaint remains deficient because not one of the 212 statements is followed by an allegation identifying the true state of facts plaintiffs contend Katie Joy's reporting contradicted. In other words, again, let me just lay this out for you, okay? According to Katie Joy, pleading that the 212 statements were false is not enough. Instead, under Katie Joy's theory, the second amended complaint must allege additional facts to establish what the true facts supposedly are. He says, arguing a defendant cannot know that a statement is false or act with reckless disregard for the truth unless there's a true state of facts against what the statement can be measured. This theory is nonsensical and is not supported by the sparse authorities offered by the defendants. So, all right, we'll see. We'll see how they argue that and what the judge says. You're chronically kind of old, but not mentally. I refuse to grow up and get all serious. Same, Susie Flies. For real. For real. And it's crazy sometimes too when people refuse to see that there's some sarcasm behind that, or there's some just whatever. If you can't see the sarcasm. But y'all caught me up on one. That's all right. Your misspelling, Susie Flies, chronologically. Okay, she says, damn, the misspellings keep coming. Just wait. Look, you'll feel better whenever we get Katie Joy's next filing, okay? Then you won't feel bad about all your misspellings. Bouquet of eau de toilette. Even when Katie Joy says, Happy Mother's Day, it sounds like malice. KJ is a menace. She has acted in malice. KJ's chat, GPT is a terrible lawyer. I truly wonder. Again, that's just me asking. I'm not putting it out there. I'm not stating it as a fact because I don't know. I mean, because if you look at stuff now that she's filed compared to what she filed before, whenever AI really wasn't readily available like this, is there a difference? You feel good. Katie is crying and drinking wine about about right now. Well, it's 1:45. It's 1:40 my time. Damn, we've been on here for 2 hours. Y'all bored with this yet? Or should we keep going? Let's see. Gotta catch up on my YouTube side of it. All right, let's see. Katie Joy. Oh, wait, see. As an initial matter, plaintiffs indisputably pled that all 1,200 statements contained false information and identified each false statement verbatim. And they did. Because, well, that's the court, they moved the court to amend the complaint. Court granted their motion, and they went back and they pled that all 212 statements contained false information, identified each false statement verbatim. They did. I've even outlined it. I've even done all 212. We haven't gotten through them all. Yes, the filings have changed from grant till now. It's interesting. Yeah, they have. They have. I'd have to really go back and look specifically. My short-term memory is, and my long-term, my memory. I got neither long-term nor short-term. I can remember certain things about this case that stick out, but a lot of times I have to go back and refer back to the actual filings. You think Katie Joy's been drinking for hours by now? Yeah, I've had people ask that. So it looks like I'm not the only one. It seems like several in here in chat think that AI could be involved in this. It makes me wonder. The reason why I bring it up is I'm just wondering if this attorney senses that. And if so, if he's going to address it. Defendant Katie Joy made the following social media posts, which include false statements of fact, malicious and misleading statements, and defamatory statements about plaintiffs and their associates. Or should we say affiliates? Because, I guess now Katie Joy can now finally understand. That is all that is required to meet the pleading standard in a defamation case. Okay. So they're saying, look, everything we've said fits. Right? That the Second Amendment complaint adequately pleads falsity. Katie argued that their complaint was deficient because statements, like she says, statements were false without explaining the true state of facts, right? That, y'all, I'm telling you, how is she going to argue some of this? Sorry, I got sidetracked again. My puppy, he's not happy that I'm not giving him attention because it's been over 2 hours. Defendants urged the court to apply a heightened pleading standard that would require 7M to not only identify the statements verbatim and allege that they are false, but also to allege what true state of facts each statement supposedly contradicts. That is not the applicable standard under Minnesota law. To support their novel suggestion, Katie Joy cite to only a few cases, each of which are inapplicable here. They say that one of them is not even a defamation case, and it does not speak to the sufficiency of a complaint asserting a defamation claim. And then this other one that they cited, he says, nor does the Hebert, or maybe it's Herbert or Hebert, instruct the court to disregard an allegation in this Second Amendment complaint that the statements are false or the plaintiffs must allege that true state of facts in order to properly allege falsity. So he's saying basically, you can't even cite shit right. But again, they're saying the Second Amendment complaint sets out, look, these statements themselves show, but we laid them all out for you. That she's giving false, misleading, and malicious defamatory information in her statements. Let's go on. There's another one. The same is true of Pierce, I guess what she cited, where the statements at issue were implied, not expressed. So he's saying everything that she pretty much tried to use doesn't even apply. And that's pretty bad, y'all. Here's another thing. Defendant's memorandum. This is funny. I'm telling you, I laughed a whole lot yesterday when I was reading this. Katie Joy's memorandum suffers from a number of defects that make its motion impossible to grant. Okay. So look, you wrote some bullshit that doesn't even apply. Okay. And here, as a real attorney, let me explain to you why. All right. Let me just go ahead and tell you. Dana Brett says AI gets case law wrong all the time. I work for an attorney. I've wondered. See, okay. Thank you for that. I've heard that. You know, when I worked for an attorney way back, you know, that wouldn't even been a question. So I wouldn't even know how to answer that now. So thank you. It makes me wonder. Now, let me ask you this, Dana Britt. Would an attorney such as this, a firm such as this, I don't know if you've looked at them. I don't know if you've looked him up, but it's it's V. John Ella in Minnesota. He's been, well, we'll just call him Super Lawyer, okay? You can go read all of his stuff. Do you think someone like this firm that he's with, whether it be him, his associate attorney, whatever, do you think they would look into it? If they look at this and go, this doesn't sound right. If they do suspect it, would they address it to the court? Susie. So basically they're saying here, look, okay, not only all this other bullshit, your memorandum suffers from a number of defects that make its motion impossible to grant. In the first place, Katie Joy filed their memorandum over the page limit. Okay. We said about this at the very, very beginning. If y'all were not in the beginning, we talked about this. You know, there's a page limit, and Katie Joy she exceeded it. She's done this before, but I don't think, well, I know Amber Stavik did not hold her feet to the flame on this. Like she didn't really say much about it. So I don't think that she was like anything really happened with it. And then I know there was another filing where Katie Joy, I believe, asked to file a filing that exceeded it. And that might've been the summary judgment, y'all. Don't quote me on that. See, that's what I was thinking. I guess my question is, do you think that do you think that there's something in Katie Joy's filing that would have piqued their interest to make them think AI was used? Does that make sense? Because yeah, an attorney can be fined for using it incorrectly. And I'm just wondering like how they prove that. For citing incorrectly. Oh, okay. You're saying an attorney can be fined for citing case law incorrectly. Like that in itself is separate from using AI. And that's why I was saying like, yeah, you're using it incorrectly because you're using AI. So I guess there's two issues there: citing incorrectly, and it's incorrect because you're using AI. And I'm just wondering if that's going to ever be brought up. I don't know. Again, can I prove that she's doing it? No. Am I trying to prove that? No. It's just something that interests me. Oh, that's interesting, Cheryl. Yes, they check it. I know several attorneys that have been fined. Good to know. Thank you. Thank you for your input. Appreciate that. Good to know. It makes me wonder. We'll just see. We'll see where it goes from here. That's what I've been told too. Someone told me that it feels and sounds like AI. I mean, that there are apps that detect it. I bet big Mr. E has one. Yeah, I'm pretty sure. I bet. What big Mr. E, what doesn't he have, right? So there's a limit. Katie Joy exceeded it, and they're calling her out. Defendants, as the moving party, obtained a hearing date for this. Okay, so, but then they say, so they're gonna list out the several things, the numerous defects that make its motion improper. There was a page limit, and they exceeded it. And as the moving party, obtained a hearing date for the motion for September 8th, 2026, and notified plaintiffs of that date on August 11th, 2026. So he's saying you knew and you acknowledged that September 8th is going to be the hearing for this motion, your motion regarding this anti-SLAPP, okay? You acknowledged it on August 11th, that September 8th is the date. And by law, they have 28 days from that date to file it within 28 days, right? They say Katie Joy filed and served their notice of motion and motion, proposed order, declaration of Catherine Paulson, and 12th declaration of Jennifer Moore on August 11th, 2026. Okay. But they neglected to file and serve their memorandum, which is the beef of it, right? Until August 12th. So remember how I was like, okay, we'll go over what we have. But when we went live, we had the notice of motion, we had a proposed order, we had Katie's declaration, we had Jennifer Moore's declaration, but we didn't have the actual memorandum. And we're like, we'll just kind of try to assume and guess what she's asking here for, what she's arguing here, until we get the memorandum. It was filed the next day. Well, he's saying that by filing it the next day, and it was filed the next day at like 4-something p.m., like 4:30 p.m. It's called 4 p.m. Okay, the next day. He's saying by filing it a day late, that took a day away from 7M being able to respond. Ordinarily, a late filed memorandum would not be so prejudicial, but in this case, the memorandum spanned 40 pages, okay? So 5 pages beyond the permissible length of the defendant's original memorandum and reply memorandum combined. So combined, it was not exceed 40 pages, and she did. And it says, given the prejudice imposed upon the plaintiffs, whose deadline to file a responsive brief was cut short by Katie Joy in the middle of their substitution of counsel, no less. I mean, he calls them out. Look, you knew we were in the middle of you knew that you had a 28-day deadline. You filed everything but what's important, the memorandum. And we went through the same thing, y'all. We're like, okay, well, we can only see so much. We couldn't really determine what her fucking argument was until we had her memorandum. But she didn't file till a day late. And he's saying that day late cut them a day short. I'm going to read that again. Given the prejudice imposed upon 7M, whose deadline to file a responsive brief was cut short by Katie Joy in the middle of their substitution of counsel, no less, 7M requests that pages 36 through 40, okay, so that would be the 5 pages that are too long, right? You're only supposed to get 35. So we want the court to delete 36 through 40. So they request that pages 36 through 40 of Katie Joy's memorandum be struck. And to the extent that Katie Joy requests permission to file a reply memorandum under the Minnesota's General Rule, Practice 115.05, that the court denies such a request. Okay. So basically, it's too long, and they want the court to strike 5 pages and deny permission for reply memorandum if one's requested by Katie Joy. So they're not only arguing the substance, they're asking the judge to penalize the motion for procedural defects, okay? So they're not just saying, okay, yeah, the substance sucks. There's something wrong with what's going on in the 36 through 40. They're like, no, you exceeded. So I want this shit gone. And y'all, when you go back and you look at pages 36 through 40, okay, it's a big chunk of this, of her massive freaking chart for the jury, right? And that, a big chunk of that being taken out would hurt her in some ways. It would take out a big argument. So hang on one second, y'all. Hang on one second. I've got to, my dog is here. Like, what are you doing? Okay. Back to this. Back to this. So yeah, take it all. Take those last 5 pages. But they're also saying, even with all 40 pages, right? 7M is saying that the motion still doesn't give enough individualized analysis to justify dismissing the statements as a whole. So you suck no matter what, Katie Joy, but we're just going to point out all of your defects, okay? Because there are several. And we need to let the judge know that we acknowledge all of your defects. You're very defective. More to the point, perhaps more strikingly, Katie Joy did not provide any statement-by-statement analysis of evidence supporting the truth, the falsity, of each allegation, and plaintiffs are therefore not required to rebut arguments on a statement-by-statement basis. So, Katie Joy, because you're going to sit here and you're going to put these in buckets or bouquets, right? Your bouquet 1 through 4 buckets are stupid, but you didn't even provide a statement-by-statement analysis of each thing, but you're expecting us to. Short order cook, thank you so much. Look, this is good because it'll give us a little bit of, let me go back. It will give me a second to stretch our legs. It's almost like we need an intermission here, don't we? I need to find some intermission music. Hold on. Let me put this up because I want to acknowledge you. Thank you so much, Short Order Cook. I appreciate you. Which one should we do? We'll do this. We need a 17-second break.
Thank you for the love and the money while we keep covering this dummy. It keeps this little channel growing so we can keep this crazy going. From the bottom of our hearts, we love you so dang much.
Thank you. Thank you. Okay. Now I'll go back. Now I'll try to take a breather. All right. Oh, love for JJ's puppy in her lap. Yeah. Barnaby's like, seriously, mama, what you doing? Look, dude, we got a lot to talk about here. There's a lot of defects going on. And these need to be addressed. Katie Joy's memorandum asked the court to dismiss wholesale entire categories of defamatory statements from the Second Amendment complaint, which defendants compiled and organized unilaterally into 4 buckets. Defendants then attempt to analyze a single statement. Oh, wait. Only by... oh, God, y'all. Now I'm getting cross-eyed for real. I'm going to try to get through this. Let me start over. Defendants compiled and organized unilaterally into 4 buckets. Defendants then attempt to analyze the statements only by reference to those categories and without individually analyzing single statements. Again, defendants' categories range in size from 7 to 11 to 113 statements, categorically dismissing large numbers of statements without individualized analysis of the statements that defendant urged the court to dismiss would be improper. So, if the court wishes to have the parties analyze individually the statements that defendants have asked the court to dismiss, plaintiffs would welcome that opportunity to do so. But Katie Joy can only be expected to adequately respond to individual analysis after defendant completes the process. Boom. You know, we're missing today is Luke. He hasn't given us our daily reminder. Poor Charlotte Luke, if you're in the bushes, you better make yourself seen. You have your dog in your lap too. Jill B. and Susie Flies. Mine's not the only like needy one. My dogs are laying on my lap too. They're so happy you're alive. They don't want me to go to the laundromat. Stay there with them. Oh, thank you so much. How do I pronounce your name? Can I just call you Subo? How do I pronounce that? Thank you for the jewels. Dog bones, Barnaby. You got 10 dog bone jewels. You said it for Luke Susie Fly. Did I miss it? Thank you for saying it for him. Laura Vonnie. Katie Joy is just a trash bag. Katie Joy is a trash bag. Opinions. These are opinions. Barnaby. I appreciate you, Helen. I should have modded you a long time ago. What was I thinking? I wasn't, clearly. Thank you, Susie. Yeah, we got lots of them. My big dogs are in there with my husband. It's so hot we can't even go outside. Yesterday, again, the heat index was 133. All right. Parties analyze individually. We already said that. Defendants request to certify questions for appeals should be denied. Okay. We went through these. I'm just going to kind of skip over this. We'll see how Katie tries to argue this, but we'll just kind of skip over it because they opposed her request to certify questions for appeal. As you remember, Katie, she asked Judge Willis to certify certain legal questions for possible appeal. We went through those, but 7M argued that the questions aren't sufficiently important or doubtful to qualify for certification. And I didn't really look much into it. And I remember we went over these questions, but I think they're just going to be denied. And they give their reasons. And they say defendants' 3 questions presented to the court are not important, not doubtful, and would not be from any order denying a motion to dismiss for failure to state a claim upon which relief may be granted or denying a motion for summary judgment. So then they go over the questions and why it doesn't work and under what framework and in the statements. I'm not going to bore you with all that because I think those are just going to be that Katie Joy already requested the judge certify some questions. And the judge was like, no, I got this covered. And remember, Katie Joy's questioning her gatekeeping. She's, but again, okay, the one thing that's important for me here to state is that two of the questions are in regards to malice. Okay. The first one and the third one. If this judge says you are private figures, you're not public figures, okay? If she says 7M are not public figures, well, then those questions are just tossed anyways, right? Because actual malice wouldn't even be considered. Because if they're not public figures, the actual malice standard does not apply. So then these questions wouldn't apply either. So I'm just curious to see how 7M responds with that. I'm curious. And so I really don't want to get too much into it. But then they say, finally, although Katie Joy's present motion may resemble the standards employed in a motion to dismiss for failure to state a claim upon which relief may be granted, or a motion to dismiss for failure to state a claim upon which relief may be granted. God, I just read that line twice. Or a motion for summary judgment. Y'all can tell I'm getting totally cross-eyed. You get me though, right? You get me. Or a motion for summary judgment. It is neither of those things. Instead, as confirmed by the caption, a defendant's own memorandum. Thank you, Lucky Pup. So now Husky, that's so cute. That is so cute. Thank you so much, Lucky Pup. I appreciate you. Y'all, I'm getting cross-eyed. Instead, as confirmed by the caption of defendant's own memorandum, defendant's motion is a special motion for expedited relief pursuant to Minnesota Statute 554.9. Defendant's memorandum of law And then they say it. Accordingly, Rule 103.03 would not permit an appeal to be taken from an order denying defendant's motion, even if the court were to certify that the questions presented is important and doubtful. Defendant's request is nothing more than a transparent effort to avoid trial and delay resolution of the case. Okay, so they're saying, boo, waste of time. I think the judge is going to agree. But particularly, I'm curious to see, because two of them, Katie Joy wants to certify a question with the appellate court about malice, and if it applies, and if this judge has, in her gatekeeping, right? Does she have the right to make that decision? But listen, if she says that they're private figures, it doesn't apply. So I'm curious how that goes. Now we're down to the good. Defendant suggests that there are too many defamatory statements is not a basis for dismissal. Remember how we talked about this? Katie Joy's like, y'all, I said so much shit. Or Katie Joy's attorney's like, yeah, my client said so much shit. She said so much shit, but let's just let it go. Let's just push them up. Forget it. And they say defendant's sample verdict form. So the sample verdict form is where part of that would have been the last 5 pages. And it was actually in relation to the statements that were made that she is, the big bucket, right? Her big bucket, the 4th bucket that had all the statements that happened that she says the anti-SLAPP would cover. Okay. The really bad defamatory statements, in my opinion, that she made. Some of those statements are in that part of it. Right. So that's what that last 5 pages, if this judge does grant that and deletes them, we'll see what the judge says. But anyways, Katie Joy's sample verdict form, presumably submitted to show that there are too many statements for a jury to consider, is not a basis for dismissal. First, this is a problem of defendants making literally. Okay. Like this guy said literally, like this is literally Katie Joy's problem because she can't shut her fucking mouth. Literally. They made a lot. Thank you, Makita. Thank you for the jewels. I appreciate you. I love those, y'all. He says literally, they made a lot of defamatory statements. As a natural result of that, the jury will necessarily be burdened. Okay, so you're causing a burden, you dumb fuck. You're the one that said all these things, you dumbass. So now, what? You don't want to burden the jury with your fuck shit? Like, come on. As a natural result of that, the jury will necessarily be burdened with weighing the evidence relevant to each statement. Second, the courts are required to litigate cases, whether they are simple or complex. You made this complex, Katie Joy, is what 7M is saying. So it is the court's requirement to litigate this case, regardless if it's complex, that your dumbass made it. She's a trash bouquet. Throw her in the trash bucket. Your pug is 11 pounds. Thank you for going over this. I've never hated someone I've never met before, but KJ is a soulless. People are like, why are you so obsessed with her? I'm not obsessed with her. I'm like fascinated by her ability to do the shit she's done. I'm fascinated by the dumbasses that come in my comment to actually say I'm obsessed, to not be able to even understand what has happened here. Mary Winchester, you think you're crushing on this lawyer, literally? I should put his picture up. Put little hearts around it for you, Mary Winchester. Third, as proposed by plaintiffs above, the central defamatory statements are readily identifiable, and the statements pled in the Second Amendment complaint as background and to establish the totality of the defendant's misconduct will be presented to the jury as such at trial. So they're saying that some of the statements that are made are background to the misconduct. The ones that they're saying are defamatory, right? So, and he's saying, look, we'll sort all that out. Calm down, cool your jets. I understand that this is your last ditch effort. I understand you've got nothing else. I understand everything that you've thrown to the wall has not stuck. It's not going to stick now. Okay. So we'll deal with this. We'll let the professionals handle this. Okay, calm down. The parties can meet and confer with each other. Now, I'm wondering if they're going to have as difficult of a time trying to meet and confer as Amber did. We've seen a lot of the communication that was had between the parties. We saw their communications in attachments, right? And filings. To put it lightly, Jennifer Moore's a bitch, in my opinion. A straight up bitch, in my opinion. I'm curious to see if when they start to show communication between Jennifer Moore and Mr. Ella, what that's going to consist of. Because he's saying, look, as a practical matter, the parties can meet and confer with each other. You know what? I'm sure he's used to meeting with other professionals, and they meet and they confer. They do their job as a lawyer. You're not going to agree with the other party, but you're there to do what's right for your client, just as the opposing party is. You're here to follow the fucking law. You're not here to argue. You're not here to talk about the opposing counsel's health concerns and matters, being hospitalized, say that they're lying. Okay? This isn't high school. We've got a professional in here now. Amber was a professional. Someone said anybody that had to deal with someone like Katie Joy and her representation, they'd quit too. They would change professions. So, yeah, send some ice this way too, Helen. So hot where you are, Mary Winchester. I missed your comment. You think Jennifer Moore will be intimidated by him? I think any good lawyer would be intimidated by him. Katie's going to look so fucking stupid when she's being questioned. I would love to see a clip of Jenny in court. She seems condescending and uninformed. I don't know when Mary says, I don't know if Shin is a nice guy, but the whole point to me is, what if Katie Joy was saying this about my dad, my brother, my husband, or my nephew? Calling a man a rapist without proof is dangerous. Exactly. Why can people, because this narrative has been sold. And by 7M staying quiet, doing the right thing, handling it through the law, I fully believe Robert Shin's going to get his money back, or at least be awarded his money back in attorney's fees, at least equal to that amount. Whether it be they grant attorneys the fees. Hey, lucky pup, thank you. Oh my gosh, how cute! That's so cute. So I don't know. We'll see. We'll see how it goes. Again, we can't put the cart before the horse, because we don't know if this is going to trial. We don't know what this judge is going to say. I think we're pretty sure. Okay. I think I'm even more certain now that she's going to deny Katie Joy's motion almost in full. But anyways, he's saying they could meet and confer with each other and the court at an appropriate time before trial to discuss means of streamlining the case to be presented to a jury. Look, you're going to sit here and make all this shit. So their only argument, we're going to end this because I've been in here a long ass time. We're going to end it with this. Katie Joy made all these statements. Hang on a second. I got to move real quick. Katie Joy made all of these statements. Bad. And we're going to continue going over them. In fact, I think we even need to review some of them. She's in a bad place. Okay. In my opinion, she's in a very bad place. She made all these statements. And then her only argument is, wait, all my statements were so much, it's going to confuse the jury. We can't do this to the jury. We can't do this to the jury. Come on, judge. Can't you see? So let me make you this long ass ridiculous fucking chart that probably cost Katie Joy all kinds of money, because how long did it take her attorney to make that stupid thing? That's just going to be tossed out the window. So that's just money out the window, right? She said all these things, but it's too much. Come on. She calls everyone a narcissist and a cult, trafficker, the works, because that's all she has. You know, you can't, yeah. And she put all the eggs in one basket thinking he's going to be arrested. He's going to be in prison. Everything I've said is just going to be tossed out. She underestimated him. And this is what happens. And now Robert Shin has incredible representation. We just saw how he laid this out. He laid it out perfectly. He was able to dispute every single thing Katie Joyce said. Right? And he broke it all down. He broke it down in like, I don't know, like 9 different areas because it was that complex. Didn't seem like it when we read through it, though, did it? There is a lot to take in here. There's a lot, Katie Joy with all these comments, statements that she made, right? She's just saying, oh no, if they don't apply under anti-SLAPP, right, then they should be dismissed because of their time barred, because of statute of limitations. And then also these other ones should be dismissed because they've already been thrown out by the court. They shouldn't be put back in. And then also ones that are showing up that were now in that were never, like you're saying I said before you sued me, but you didn't put it in the original complaint. So why are you putting it in this complaint? If it didn't matter then, why should it matter now? So she has all these things of saying, well, these statements, in these 4 bouquets, right? We're gonna put them in these buckets. If anti-SLAPP doesn't work, then you got to dismiss them on these standards, right? And 7M is like, no. I'm just going to shoot all them down. And, come on, judge. Clearly you need to deny her special motion to dismiss, right? And deny her request for attorney's fees and costs. Again, for me, one of the biggest arguments is that what they're saying is your argument about sorry, let me get where I was. Your argument about these statements. Okay, I forget what I was saying. Me. It's too long. I've been on here way too long. Yeah, I agree. I mean, it just makes me wonder. Now I'm just gonna chat with y'all for a little bit, not give my brain a break. That was a lot. That was a lot to take in. It's been almost 3 hours. My husband's probably like, what the hell? He's usually not home whenever I go live. I don't like going live when he's home, but he's working from home. So it's not an issue, but I just don't like to do it on the weekends or whatnot. But you can't figure out how to tag when you're replying. I think you have to be on a PC or laptop to reply. You click on their name. Let me see. Well, I'm a moderator, so I can. Thank you, Blake. Thank you for the reminder. Let me pin that. I appreciate you. At my hospital, the vet techs take home all spare and unclaimed animals. Do they really? What did I just say? Unspared? You said unspayed, right? Hold on. Where am I even reading this? Now I'm on another screen. Y'all, my brain. See, okay, now I'm kind of looking up at chat. J. Marie, exactly. If one has information that another is doing all these things KJ is accusing Shin of, would you announce the world? Would you go to the authorities? She's admitting that she's gone to the authorities. And she's saying, well, I'm going to the world so they can also go to the authorities. Because in my opinion, it's because she needs Robert Shin behind bars. And not for the right reasons. She needs him behind bars because she needs this lawsuit to go away. She's saying she's advocating. She's not. If you're advocating, you'd be doing this shit behind the scenes. You would not be pushing who you're labeling a victim further into this, what you're calling a cult. You are putting her further in. I mean, you're just, and they said it here. We're going to end it here because my brain is shot. This lawsuit is about a social media agitator masquerading as an investigative journalist who has ruined the lives of Robert Shin, Miranda Derrick, and James Derrick by manufacturing false accusations against them and posting them on the internet for clicks, revenue, and attention. Okay. The court is well aware of the specific facts and background because defendants disseminated these allegations with no factual or evidentiary, and I can't read that because I've got something in the way. But basically that Katie Joy has lost of protection under the First Amendment, right? Okay, so again, they're saying we're not public figures, we're private figures. We'll see what the judge has to say about that. If the judge agrees, then it takes away the whole fight regarding actual malice. And it's really bad for Katie Joy. They're saying that this was never a public concern. So therefore, they're not public figures. But not only that, she made it a public concern. And what she's done by making it a public concern has, according to them right here, ruined the lives of plaintiffs. So we'll see. We'll see what the judge has to. Katie Joy should have 7 days from the 25th. So they filed this on the 25th when it was due. We didn't see it till the 27th, but it was filed on the 25th. They didn't even try to file it a day late and argue it. They filed it on time. This guy follows his shit. You could tell he follows the court's orders. He follows timelines. He's going to be one of those that's going to follow. As soon as we finally see another scheduling order in this case, right? I'm not saying that Amber Stavick didn't. I'm not saying that at all. But I'm really curious to see what happens. So Katie Joy has 7 days from the 25th to reply. I think I'll still be out of town. But again, it might not show that day. Some of them showing a day late, whatever. Like this one didn't show for 2 days, but it was filed on the 25th. I hope she has to give 7M all profits from her content on them. They're asking for that, Sarah. So yeah, I mean, that will be something for if this goes to trial. Okay. I'm just feeling it's projected to go to trial. That doesn't mean that it's going to, right? It's projected, in my opinion. Thank you so much, Laura. A trophy cake. Thank you so much. I appreciate you. We should do a collection so you can pull resources and go to trial. Well, Makita, I'm trying to say it without saying it. Because I don't like to make promises about something, but I am going to tell you that all the things that come in on this channel, memberships are very important. All the super chats, all the things that come through that help this channel financially. Okay. That is going to go to a way for all of my supporters and viewers to know what's happening each day at trial. I hope that makes sense. And I'll keep saying that. But once we see that this is headed to trial, like when we know that the judge, let's say the judge shuts Katie Joy down on all this, she shuts her down on anything that comes beyond this, we get to the point to where, okay, we know what's headed to trial. We know what statements are headed to trial, whether it be all 212, whether it be 192, whatever it may be. We know what's headed to trial. We know what the jury is going to have to consider. And we're going to know if the jury is going to view them as public figures or private figures. Okay. Once we know all that, there's a date set and it's going to happen, then I'll start making those announcements. I'll start making those statements. Right. But even then, money, Helen, thank you for your £19.99. I appreciate you. That was not a money grab. I promise you that was not a money grab. I appreciate you so much. Again, it will help and it will keep you guys in the know.
Thank you for the love and the keep covering this dummy. It keeps this little channel growing, so we can keep this crazy going. From the bottom of our hearts, we love you so dang much.
Weezy, you too. Have a great weekend. I totally forgot it was Friday. Totally forgot it was Friday. Thank you, Helen. I appreciate you. But yes, my goal is, and even if it's secondhand, whatever, I'm making the promise that you guys will know what's happening at the trial. If it goes to trial. If it doesn't, we'll just go over all the transcripts and everything that we can get to see why it doesn't go to trial. Thank you, Helen. All right. Susie, I appreciate that. All right, everybody. 3 hours is too long. It went by fast. I appreciate each and every one of you. Thank you for sticking with me. Thank you for being here with me. I appreciate all of you being so kind to one another in chat. I appreciate the fact that if you disagree, we have the ability to agree to disagree. I appreciate my mods that are in here, that if we get out of control with a disagreement, I trust their judgment to just silence them and let me know. And we're going to keep following this. I'm going to be gone probably till next Friday. If anything comes up, you'll see a post from me. I'll try. I love you, Tilby. I will try to make a video on this. I don't think I'll have time. I think we covered it well enough on here. I might make a video once there's a ruling, so I can go over Katie Joy's motion, 7M's response, Katie Joy's response, the ruling, and then make a video from that. So thank you for your time, says Tessa. Thank you for being here. All right, everybody. Have a wonderful day. It's hot as hell here. Stay cool, stay warm if you're in Australia. I appreciate each and every one of you thank you for all the ice, Helen. For all the super chats, all of it, being members, the gifted memberships. Appreciate each and every one of you. Susie Flies, I'm not a mod. Oh, are you? Well, Susie might just find a wrench one day. Just kidding. I don't expect anything out of my mods other than just to silence when people come in here and they want to talk about other creators. I don't care if they dog me. You can say what you want about me. I can handle that. But we're not going to talk about the plaintiffs in this case unless it's on a reasonable level. Like if I'm communicating with this person saying, okay, look, we can agree to disagree. If it gets out of hand, I'll just block them. But if I'm not paying attention, I don't see it. Silencing them is just the best thing, just to mute them. So, but I appreciate my mods. I don't have many because I don't need many right now. We might get to the point, hopefully, if this goes to trial, where I will need more mods. And I pay attention to who's in my chat. I pay attention to how everybody reacts. And I appreciate each and every one of you. I'm going to shut up now because my dog is giving me sad eyes. Again, I appreciate each and every one of you. Have a wonderful day. I'll probably see you in a week. If anything happens in between then, I will make a post on YouTube to keep you updated. Balls, who was in here earlier, she stays on top of it apparently. So you can go visit her on Twitter or Instagram, whichever one's your fave. Go over there to see what's posted. I think she posts everything that Katie Joy says, not just about this lawsuit. So I only post about this lawsuit for the most part. All right. Bye. Bye, y'all.
It don't take a crystal ball to know how some stories end. When someone keeps saying opinions like facts, the courts start listening. Southern mutton don't predict nothing, we just watch and write it down. Don't need a crystal ball to see it coming back around. When you state it like a fact and never check it first. Southern mutton, watch it close from the courthouse ground. True, stay patient while the paper getting worse. Same routine, new headline phone. Same bold claims that the record don't want. She speak real loud, no maybe, no seems. Turn opinions into facts like the courtroom clean. I ain't wishing nothing, I just seen the signs. When the words outrun proof, it's a matter of time. History repeat when you don't learn yet. Courts don't care what you meant, just what you said. When confidence louder than evidence be, that's when patterns start explaining things to me. Don't need a crystal ball to see it coming back around. When you speak like a verdict before the truth's found. Southern mutton in the case, boots firm on the tile. We don't chase drama, we just watch the file, yeah. Country rap,
I don't glow or grin. I just read the docket when it rolled back in. She called it truth, call it just how it is. But courts draw lines where the talking ends. I ain't psychic, I'm observing. Facts don't bend cause a voice is urgent. From testimony tone to the written page, same outcome when the pattern don't change. Lies like speed, truth like distance. One burns fast, one keeps existing. On lies like speed, truth like distance. One burns fast, one keeps existing. Don't need a crystal ball, don't need belief. When the law still runs on proof and receipts. Southern mud and watching through the courtroom glass, pointing out lies as they saying it's facts. Yeah. This ain't prophecy, this ain't hate, just history watching itself repeat. When words get reckless, the courts get busy, and the truth always shows up right on time.